Hello students, I know that everyone will be in your last round of preparation for your examination. So we will have a quick revision into the amendments which are applicable for December 2025 examination. So as usually I mentioned during the amendment video, I have included all the amendments which have taken place in the past 2 or 3 years so that the students who are writing after a small break or a small gap will also be benefited from this discussion. Okay, so we'll first move to the definition of MSME. So the amendment in MSME was brought on 1st of April 2025. So I was mentioning during the last examination, during the amendment session of June 2025 examination that amendment was not applicable for June examination, but it is applicable for December 2025 examination. Okay, so the new definition is like this. Investment, you know that MSME is related, MSME is having its definition from investment in plant and machinery or equipment and annual turnover, right? Okay, so for the micro, investment in plant and machinery or equipment is not more than 2.5 CR and not more than 10 CR. Okay, earlier it was 1 CR and 5 CR. Now it is changed to 2.5 CR and 10 CR. Then for small, it is not more than 25 CR and not more than 100 CR, not more than 125 CR and not more than 500 CR for medium. Okay, so this is a change which is in MSME. Okay, then we'll move to the provision of Sarfasi Act. So in Sarfasi Act, we are discussing about the registration of asset reconstruction company. So the minimum net on fund requirement is there. So as per the act, it is 2 CR. Okay. So as per the master guidelines of RBI, the amount has been raised to 300 crore. Now it is 300 crore, and every asset reconstruction company which is existing on this date will have to comply the provision by 31st of March 2026. Means if a new company is incorporating as asset reconstruction company today, they will have to comply the minimum net on fund requirement as 300 crore. That means the minimum net on fund requirement as on day is 300 CR. All the existing ARCs which were registered or incorporated under the prior provision will have to comply the provision of 300 crore by 31st of March 2026. Okay, so minimum net on fund is rupees 300 crore or above. For this examination, you have to note, please note in your mind, for this December 2025 examination, minimum NOF is 300 crore. So the provision was like this. On 11th of October 2022, the amount was brought to 100 CR by RBI. On 31st of by 31st of March 2024, RBI has directed all ARCs to have net on fund by of rupees 200 CR, and by 31st of March 2026, all the ARCs to have minimum net on fund of rupees 300 CR. Okay, so I think the discussion is clear. So I'm repeating once again. The net on fund requirement as on the day is 300 CR, but all the ARCs which were existing, which were registered under any prior net on fund requirement will have to comply this 300 crore by 31st of March 2026. Okay. Then under Competition Act, this amendment was there for your June 2025 examination also. So threshold of combination has undergone some amendment. Exclusive dealing agreement. Under anti-competitive agreement, you have horizontal agreement and vertical agreement. Exclusive dealing agreement is now the new term for exclusive supply agreement. So now there is no exclusive supply agreement. It is termed as exclusive dealing agreement. Then we have a small amendment on appreciable adverse effect on competition. So I'll discuss the provision of combination threshold. So combination threshold, the new threshold is for individual if enterprises have assets and turnover only in India more than 2500 CR or more than 7,500 CR. It was 2,000 and 6,000. Now it is being changed to 2,500 CR or 7,500 CR. So the group has undergone change. It is 10,000 CR or 30,000 CR. Then any enterprise has assets or turnover outside India for individual more than USD 1.25 billion, more than 3.75 billion. Then Indian component is 1,250 crore and 3,750 crore if it is in the case of turnover. In the case of group, it is more than USD 5 billion and minimum rupees 1,250 crore in India. Indian component will not be changed. Okay, Indian component was earlier 1,000 crore and 3,000 crore. Now it has undergone change as 1,250 crore and 3,750 crore. Then in the case of turnover, it is more than 15 billion and minimum 3,750 crore in India. And you know that assets, the amount of turnover will be 3 times that of assets. Okay, and individual versus group will be 4 times. So in the earlier provisions also this was the case. It was 2,000 and 8,000 with respect to individual and group. Now it is 2,500 and 10,000. Okay, so these are the provisions amended with respect to the thresholds in combination. Then exclusive dealing agreement has been substituted for exclusive supply agreement. Under vertical anti-competitive agreement, you cannot, there is no exclusive supply agreement. The term has been changed. The name has been changed to exclusive dealing agreement. The definition remained the same, only the term has undergone change. Same in the case of appreciable adverse effect on competition under section 3. You are having some definition in that foreclosure of competition by hindering entry into the market was there. So hindering entry into the market is now omitted. So it is now only foreclosure of competition. And in the fourth point, affecting accrual of benefit or harm to customers, it has now been changed to benefit or harm to customers. Just difference or change in certain terms only. Foreclosure of competition is there, then benefit or harm to customers. Okay, so that provisions were changed in your Competition Act. So with respect to incorporation of company, you are having 3 changes. Please note that these changes have been made, or these amendments have been made years back. It is not in 2025 or 2024. These provisions are being discussed to benefit the students who are writing the examination after a small break. Okay, or if someone is referring the material, in material you might be seeing the old provision. So only for that purpose we are discussing this one. So with respect to small company, the new provision means on 1st of December 2025, just 2 or 3 days back, there was an amendment notification from MCA that new definition of small company is 10 crore and 100 crore. But that is not applicable. Please note that amendment, that notification which was made on 1st of December 2025 is not applicable for December examination. So for December examination, the small company threshold will be not exceeding 4 CR and turnover not exceeding 40 crore. So don't get confused. You might have seen so many status of your students, so many stories of your colleagues and all. So that notification was made on 1st of December 2025, which will be applicable only for June 2026 examination. So for this examination, your threshold will be 4 crore and 40 crore. Okay. Then resident status in OPC. OPC can now be incorporated by natural person who is citizen of India, whether resident in India or otherwise. In material, it might be noted that he has to be resident. That provision is not there. He can be resident, or if non-resident also, there is no issue. So the resident minimum 120 days stay is specified. So these changes were made after COVID-19. Okay, so in material there will be different provisions, so don't get confused. Resident in OPC is not mandatory now. The member of OPC, sole member of OPC can or cannot be resident. Then conversion of OPC. OPC can now be converted to private or public at any time. 2 years time limit and provision regarding exceeding the threshold. 50 lakh paid up, 2 crore turnover was there. That provision has been removed. Okay. Then now we'll move to the provisions amendments regarding meetings of board and its powers. Chapter 12 of Companies Act. So one amendment was regarding related party transaction, then omitting of rule number 4, then changes in audit committee and nomination and remuneration committee, NRC. So under 188, section 188, when we are discussing about the related party transactions threshold, the earlier threshold was like 10% or 100 crore, whichever is less and all. Now that provision, now means it was changed 3 years back. This provision is like this: sale, purchase or supply of materials amounting to 10% of turnover, selling or disposing, buying of property amounting to 10% or more of net worth, leasing 10% or more of turnover, availing or rendering of any services amounting to 10% or more of turnover. So please note, the students who have attended my classes or attended any classes during this 1 year, they will not be seeing any change because they have studied this actual provision. But I'm telling this will be, or this is aimed at students who had studied 3 years or 4 years back and now writing the examination. Okay, and I think in material also this is not corrected or this is not amended. Then rule number 4, which was related to matters which should not be discussed through VC or OAVM. Other audiovisual means, so which is OAVM. So certain matters were there: approval of annual financial statement, board's report, prospectus, etc. Before COVID, this was not allowed through video conferencing, OAVM. Okay. After COVID, this provision has been omitted. Now there is no rule for all these provisions, all these items can be discussed through VC or AVM also. Now it is not there. Okay. Then non-applicability of audit and NRC. So you know that in with respect to your independent directors threshold, independent director is applicable to listed company and unlisted company having paid up 10 crore or above, turnover of 100 crore or above, outstanding loan debenture deposit in excess of 50 crore. So we have a new provision that if an unlisted company failed to satisfy these threshold, paid up 10 crore, turnover 100 crore, outstanding loan debenture deposit in excess of 50 crore for 3 consecutive financial years, it is not required to constitute or not required to appoint independent directors, not required to constitute audit committee, not required to constitute nomination and remuneration committee till it meets the criteria again. So if for 3 consecutive years, if they are not meeting the threshold, for the next year, there is no need to appoint independent director, no need to constitute audit committee, no need to constitute NRC. But when the threshold is again moving to 10 crore, 100 crore or more than 50 crore, they will be under this provision again. Okay. Then we have amendment with respect to acceptance of deposit. There is a change in deposit repayment reserve. It was an amendment which was made 3 years back. Deposit repayment reserve was changed to 20% from 15%. Then acceptance of deposit by private limited company. So deposit repayment reserve, minimum 20% of the amount has to be maintained in DRR, to be maintained on or before 30th of April. It was earlier 15%. Now it is 20%. Then acceptance of deposit by private limited company, it is now maximum 100% of paid up free reserves and security premium. Okay, yes. Then Insolvency and Bankruptcy Code 2016, we have an amendment with respect to filing of application by financial creditor under section 7. Then section 11, person who cannot initiate insolvency resolution. So under section 7, in case of financial creditors of debt or securities, application shall be filed by, if debenture holders, if deposit holders are making an application, it has to be filed by 100 financial creditors or 10% of such creditors, whichever is less. Okay. So with respect to debtor securities, financial creditors of debtor securities. Then with respect to section 11, which is being asked for almost all the institutes are being, all the institutes used to ask this question. as a direct question persons who are not entitled to make application for CIRP or insolvency resolution. So in this, which I have the items or the points which I have mentioned in red are amended portions. So number one is corporate debtor undergoing CIRP or pre-packaged insolvency resolution process. Financial creditor, operational creditor or corporate debtor undergoing pre-packaged insolvency resolution process. Corporate debtor having been completed CIRP 12 months preceding date of application, that was the same provision. Corporate debtor in respect of whom a resolution plan has been approved 12 months preceding date of application. Corporate debtor or financial creditor who has violated terms of resolution plan approved 12 months before date of application. Corporate debtor in respect of whom a liquidation order has been passed. So please keep in mind this question is being asked for ICAI, ICSI and ICMI used to ask this question as a direct question. I think for December 2024 examination this question was there. So this question usually is being asked as a direct question only. Okay. Then we have certain amendments which is related to the SEBI provisions. So there is a change in definition of persons deemed to be connected. Then unpublished price sensitive information, trading plan, person not eligible to make IPO, FPO, lock-in period for excess over minimum promoter contribution, appointment of monitoring agency. So the definition of UPSI is that is or that change has been made by SEBI and that is applicable for December 2025 examination. All other provisions were applicable for your June 2025 examination also. Okay, so UPSI change was made by SEBI on June. Okay, so that provision is applicable for December 2025 examination. So we'll first discuss about persons who are deemed to be connected. Earlier it was immediate relative of connected person. Now it is relative of connected person. Okay, so the definition of relative has some change with respect to immediate relative. Relative includes spouse, parent of person or spouse. This is new one which is related to immediate relative. Sibling of person or spouse, child of person or spouse, spouse of sibling, then spouse of child. So earlier there were 10 points. Now we are having 12 points. Okay. Then 11th point is a firm or partner or its employee in which the connected person is partner, a person sharing household or residence with the connected person. Okay. So for immediate relative, there were clauses A to J. For relative, there are clauses A to, for persons who are deemed to be connected, persons who are deemed to be connected, there were 10 clauses A to J. Now that has been changed to A to L. 12 clauses are there. I have included the 11th and 12th. And in the first clause, clause number A, immediate relative is now changed to relative, and the definition of relative is spouse of person, parent of person or spouse, sibling of person or spouse, child of person or spouse, spouse of sibling, spouse of child. Okay. With respect to unpublished price sensitive information UPSI, there were only 5 points. And I used to tell my students that after amendment, you will have 16 points. Okay, so it is financial result, dividend, change in capital structure, merger, demerger, amalgamation, acquisition, delisting, disposal, expansion, award or termination of orders, contracts not in the ordinary course of business, and such other transactions. Simply you can say merger, demerger, amalgamation, etc. Then change in KMP other than due to superannuation or end of term, and resignation of statutory auditor or secretarial auditor. Okay, then sixth one, change in rating other than ESG rating, fund raising proposed to be undertaken, agreements which may impact the management or control of company, frauds or defaults by company, promoter, director, KMP, subsidiary, or arrest of KMP, promoter, director of company, whether occurred in India or abroad. Then resolution plan restructuring or one-time settlement in relation to loans borrowing from bank or financial institution, admission of winding up petition filed by any party creditors or admission of application filed by corporate applicant, financial creditor for initiating CRP against the company or approval or rejection of resolution plan under IBC 2016, initiation of forensic audit and receipt of forensic audit report, then actions which are initiated or orders passed within India or abroad by company against the company, promoter, KMP, director, subsidiary by regulatory authority, statutory authority, enforcement authority, judicial body, outcome of any litigation or dispute which may have an impact on the company, then giving of guarantee, indemnity, becoming a surety for any third party not in the ordinary course of business, granting, withdrawal, surrender, cancellation or suspension of any key license or regulatory approvals. So you might have learned 5 points. Now you have to learn 11 more points. So I know that when I was discussing that, many of you will be keeping in mind, or you might be thinking that it's very difficult to learn all these points. Just go through the points, just understand what is UPSI. Okay, institute may not be asking, I don't know whether they'll be asking or not, but more than 50% we can say that they will not be asking what is UPSI and all. Even if it is asked, if this provisions, this 16 provisions are not by hearted in your mind, you just think about the concept of UPSI, which the provisions which are not published, and when it is published it will be affecting the price of securities. Okay, so don't use so much of time. If you are having very limited time for your examination, so don't give so much of time to learn this provision by heart. Just understand the concept, just understand what is UPSI, and if it is being asked, just write accordingly. Okay, yes. Then for trading plan, there were 4 provisions. Now there are only 2 provisions. Trading plan can be executed. Earlier it was 6 months. After 6 months, now it is after 120 days of public disclosure. Then the second point, trading cannot be made during the period from 20th trading day prior to last financial period and second trading day. That is now omitted. There is no such provision. Plan shall be for minimum 12 months. No such provision. 2 trading plans cannot be overlapped. So only 2 provisions are there, and one has changed its 6 months to 120 days. Then in SEBI ICDR regulation, these all changes have been made 3 years back. Willful defaulter shall be substituted by willful defaulter or fraudulent borrowers. Amount for general corporate purpose and unidentified purpose shall not exceed 35%. Promoters lock-in period is now 18 months from 3 years. Lock-in period for amount exceeding promoters contributed is reduced to 6 months from 1 year. Okay. Then credit rating agency, earlier it was bank or financial institution. They CRA to be appointed as monitoring agency if issue size exceeds 100 CR. Earlier it was bank, financial institution, insurance company. Now it is CRA. Then credit rating agency will be appointed as monitoring agency. They will have to submit report every quarter. It was 95%. Now it is 100% of the receipts are utilized. Okay. Yes. Then the last amendment is regarding the Information Technology IT Act. Punishment under 72A. It was imprisonment or penalty. Now it is penalty up to rupees 25 lakh. Okay. So I think the discussion is clear. Okay. So with respect to the definition of UPSI, I am again repeating, don't give so much of time. Oh, okay, for learning such provisions by hearted. Just think in mind what is UPSI and just write the provisions accordingly. Conceptual clarity is very important. Okay, so apart from UPSI, all the provisions were discussed during June 25 examination, and almost all the provisions are very simple also. Okay, UPSI definition is a lengthy one, but still it is simple if you are understanding the concept. Okay, so these all are the changes which are applicable for your December 2025 examination, and all the best for your examination. If you are having any queries, any doubts, please do ask. Thank you and all the best.